Hi everyone. Thanks for waiting just a couple of minutes for us to get started. And welcome to the session this afternoon. For those that don't know me, I'm Ben. I'm the Employment Relations and Investigations Business Partner at Southeast Employers. And we're really excited to be joined this afternoon by Peter from MPM Legal to go through a sort of first look, if you like, at the Employment Rights Bill. So thanks for joining us, and particularly for joining our event, because we're very mindful there's a lot out there at the moment um, uh, on this topic. So thanks for signing up and giving us 90 minutes or so of your time this afternoon. Session is being recorded, so if you've got colleagues that couldn't attend and that kind of thing, it will be recorded and sent out to everybody. And you should have received a notification as you joined about recording and consent for audio and video and that kind of thing. Um, so in terms of a format, I'm going to shortly hand over to Peter, who's going to take us through kind of the first half of today's session, having a look at what the bill means and what it entails. That will last about 45 minutes, and we're then going to divvy everybody up into some breakout groups with the wonders of technology, touch wood. We will set some questions for those. We've just got 3 questions that we'd like you to consider in those. And we will then reconvene and feed back to Peter for a bit of an expert opinion on some of the feedback out of those breakout groups. Finally, at the end, there will be the opportunity for questions and answers, but we're happy to have questions coming in via either the chat or the Q&A function that you should be able to see on your screen as we go. So don't be shy. Please do just chuck them in there, because it means that even if we don't get to them at the end, we can take them away and come back with an answer and circulate those to everybody. So without further ado, Peter, I'll hand over to you.
Thanks very much, Ben, and nice to welcome you all to this session today, and thank you for having me along to speak. Just as a very short introduction, I'm Peter from a firm called MPM Legal. I've been an employment lawyer for 20 years this month, I figured out today, so quite a long time, and there isn't a week that goes by where I'm not surprised by something in the world of HR or employment law, so every day is a new day for me. And certainly the government are going to be keeping me very busy, and all of us very busy for the next few years, for the foreseeable future, with all of these developments. Now we have the publication of the Employment Rights Bill. It's been pretty much all employment lawyers have been talking about since it was published on the 10th of October. And for any of you that are users of LinkedIn or other social media outlets, your feeds have probably been full of people like me talking about different provisions on it. We know it's been born out of a focus to tackle exploitation, abuse, unscrupulous employers and poor treatment of workers. And if we look at the comments that Angela Rayner says in the foreword to the bill, she says these reforms will raise the floor and end the race to the bottom that some compete on: low pay, low standards and job insecurity. So they're really the main themes of this bill. What I would say about it in general terms is there has, of course, been an awful lot to consider in it. It's a meaty document for any of you that have page turned it. It is just a first pass, so a lot of it is going to be subject to consultation. Inevitably, there's going to be elements that are going to change. For example, we're going to come on first and talk about probationary periods. Will they be 9 months? Will they be 6 months? So it isn't in any way, shape or form the final finished, polished article. And I think that's really what we can expect, given the government were really keen to get something out within their first 100 days of office, which was what their manifesto commitment was. I think it was day 98 that this was published on, so they just sneaked in. What I wanted to focus on in this 45-minute slot that I've got, just some of the key themes that I think are going to be the most relevant, and I can touch on some of the other areas of change as well. And so we are kicking off, if I can get the tech to work, with probationary periods and day 1 unfair dismissal rights. So this is a screen grab of the amendment that's set out in the draft bill. And the proposal is that Part 10 of the Employment Rights Act, which is the relevant part that deals with unfair dismissal procedures, are going to omit Section 108, which is the qualifying period of employment. Now, it's interesting, actually, the way the government has gone about this, because in other sessions that I've talked about when I've been kind of researching in the past, once the manifesto commitments were put in place, we were kind of wondering about how quickly the government could bring this particular change in. And it's already open to the government to use existing legislation, to use regulations, statutory instruments to be able to change the qualifying period. They could change it within a really, really short timescale. But what they're proposing to do is change it through primary legislation. And we think the reason that they want to do that is it makes it difficult to unpick. So if they changed it via regulation, like the qualifying period has been changed in relatively recent years, that would be very easy for a future government to undo. Putting it into primary legislation means that any new government in the future would need to bring their own primary legislation to undo this change. And we know that's difficult, it's complicated, it takes time, there needs to be consultation on it. So we can see that once this change comes in, there is going to be a degree of permanence to it. So what's the position at the moment so far as probationary periods and day one unfair dismissal rights are concerned? Well, currently there is a 2-year qualification period for Section 98 claims, which are your ordinary unfair dismissal claims. So what that means is employees have to work for that 2-year period before they can go to the employment tribunal and bring a claim to say, hey, I think my employer has unfairly dismissed me. There are some exceptions to that rule. There are no qualifying periods for most automatically unfair dismissals, and there's no qualifying period for things like discrimination claims either. But the main kind of basic unfair dismissal claim has a very long 2-year qualification period. In addition, we have no concept of a statutory probation period. So although it's commonplace that lots and lots of organisations will operate a probation period, or at least their contracts of employment will refer to a probation period, that isn't written into law at all. So places are free to set whatever probation period they see fit, be it 3 months, 6 months, 9 months, 12 months, whatever they like. And at the moment, employers have the luxury of time. So if you hire somebody and it isn't working out, you can dismiss them really without concern of a Section 98 ordinary unfair dismissal claim, because somebody needs to be with you for that 2-year period. If you can be sure that there's no discrimination risk, there's no automatic unfair dismissal risk, then you've got a lot of leeway as an employer to make decisions at early stages of the employment relationship. This government don't like that. They say that it's very one-sided. They say that it's inflexible, it's not good practice, and really it promotes job insecurity. So what they're proposing to do about it is come up with this concept of a statutory probationary period, which is significant because it will be the first time ever that we have in law the idea of a probationary period. Now, the government has said they think that statutory period should be 9 months. However, they are going to consult on that, and it may be that we land on something like 6 months. A lot of the commentators were stipulating and guessing that it probably was going to be around the 6-month period, and I think leaks from government suggested it was going to be around that mark. So we were caught off guard a little bit when the bill came out and it suggested 9 months. It's quite a long period of time. The bill also talks about how there'll be a different standard of reasonableness for dismissals within this time. So in terms of how unfair dismissal liability is decided for ordinary dismissals, they're looking at applying a slightly different test in terms of deciding whether or not a probationary dismissal is reasonable. This period will also apply up to 3 months' notice for dismissals in a probation period as well. So by that I mean, what we potentially will have is a 9-month probationary period. As you're getting towards the end of the 9-month probationary period, you're able to give up to 3 months notice of dismissal. So in reality, a new joiner's employment could last for almost a full 12-month period, but they would still be availed of the protections given by this bill. So it will apply up to and the end of a 3-month notice period. When the government talks about day one unfair dismissal rights, they mean from day one. So employment must have started. But the way they envisage this working is an employee starts a job, it doesn't work out, the employer dismisses during the probation period, the employee can still claim unfair dismissal. Now, the employer has to be able to show that the reason for dismissal was for conduct, capability, a statutory ban, or some other substantial reason, that's SOSR, which is normally the catch-all reason, related to the employee. Now, those of you that are familiar with what the Employment Rights Act says at the moment will recognise those terms because they bear out the normal fair reasons when you're allowed to dismiss an employee. Of note, though, redundancy is excluded from these rules. Okay. Now, what that means is if you take on a new hire, and let's say 6 months into the employment relationship, there is a redundancy situation such that you need to terminate employment by reason of redundancy, the individual is still protected with their day one unfair dismissal rights. As an employer, you can't rely on whatever these lighter touch unfair dismissal probationary period rules will be, because it's a redundancy dismissal and they're excluded. You will be expected to follow your regular redundancy process and regular redundancy rules. And of course, the risk there is if you get those processes wrong, you've got exposure to an unfair redundancy claim. And finally, the government are saying what we would like employers to have to do is follow a lighter touch and less onerous dismissal process, which will apply during this probationary period. So obviously, the key consideration here is going to be around the management of the probationary periods themselves. And our advice is that you need a clear and fair process. And one of the main drivers for that is the government is saying 9 million employees are going to have the benefit of unfair dismissal rights as a result of these changes that otherwise, currently don't have the protection from unfair dismissal. So it is a really, really significant change. On this slide here, just set out some points to think about and some areas of uncertainty for us at the moment. And I'd love to be able to give you all of the answers today, but unfortunately, we're not going to get them yet. There is going to be this consultation period on exactly how the rules should apply. But some of the things to be thinking about are you going to apply just the statutory probationary period, which may be 9 months, maybe 6 months, but let's say it's 9 months? Or are you going to have your own contractual probationary period instead, which will be for a shorter period of time, presumably? Will the probationary period determine the length of notice? So it's quite common we see clients will have, say, a 1-week notice period during a probation. Once the probation has been successfully completed, notice increases up to, say, a month. So are you still going to have that distinction? What non-statutory benefits are going to apply during the probationary period? So do you need to flex on any of those and make a distinction between those who are in a probation period and those who complete a 9-month probationary period? In terms of the management of the probation periods, which, as I say, is going to be quite critical, do you need to review recruitment processes? So you go a step before that. So are you minimizing the risk of getting, in inverted commas, a bad hire? What about manager training? So who are the people within your organizations who are actually responsible for managing people who are within a probationary period and then making a decision about whether it's been successful or not? So are managers up to speed in terms of what the regulatory framework here is, what the consequences of getting it wrong are, where the legal liability sits? Linked to that is what probationary framework are you going to put in place? So you put in place the guardrails for managers to follow so everybody knows the rules. Is there going to be consistent application of those rules as well? A really common thing that we see is you might get a very well drafted employment contract and it has some really good provisions about probationary periods, but they're not actually followed in practice by the organisation. Or there's a really inconsistent application of those principles within the same organisation, and that can present a challenge. One of the challenges it presents is inconsistent treatment forms the basis of any type of discrimination claim. where you've got the possibility of one person saying, well, I was treated this way, so and so over there was treated differently to me during their probationary period. Here's the difference between us, insert whatever protected characteristic, and I believe that's the real reason why I was treated a certain way. The imposition of these rules overlays another element of risk to that, which is now an ordinary unfair dismissal risk as well. And then the final point there is about performance expectations. So are you being clear enough in terms of, with the employee, what they need to do to pass their probationary period, and with the person who's responsible for assessing the probation period, what they're assessing against? Are those two things in sync? Because again, that's another common area of dispute that we can see. Now, normally, at the moment, it's of no consequence, really, because you're not going to be facing an ordinary unfair dismissal risk if you really hash up a probation period, assuming there's no discrimination or whistleblowing type risk. But all of that is going to change. So it's really going to put the management of probationary periods into sharp focus. Okay. Sorry, I should have said at the start, the first slide, you probably saw my colleague's name on there. Unfortunately, she's dealing with a family emergency that's come up this afternoon, which is why I'm flying solo this afternoon. So you've got to bear with me during this, unfortunately. So that's probationary periods, and no doubt when we come to the Q&A sessions, you're probably going to have a lot of questions about how all of that is going to work in practice. The second area that I wanted to talk to you about are the provisions in the bill concerning change management. And we've got two limbs to change management covered within the Employment Rights Bill. So the first is in relation to establishments, and I'll come on and explain what that means in a moment. The second I'll come on to later is about dismissal and re-engagement exercises as well. Now, I think really, I would say the focus for these provisions within the Employment Rights Bill really comes from the whole P&O Ferries debacle and the whole wave of public outcry about what happened in that situation a few years ago now. And there've also been a couple of tribunal claims or litigation, I think Court of Appeal level decisions that have looked at a bit of legislation called the Trade Union and Labour Relations Consolidation Act, which is a bit of a mouthful, dates back to 1992. For those of you that are not familiar with this bit of legislation, what it does is it governs the rules around large-scale change projects and when there are rules to follow about collective consultation. And typically, if you recognise a trade union, and I expect a lot of you will be from organisations that will recognise trade unions, it governs the rules around when trade unions need to be engaged in terms of those change processes. So predominantly, we're talking about collective redundancy provisions, and we're talking about changes to terms and conditions of employment that trigger collective consultation obligations as well. So the current position, what the law says at the moment is that if there's a large-scale redundancy exercise, the employer must engage with the trade union, or where there isn't a recognised trade union, with elected employee representatives. And I expect a lot of you have gone through these types of processes, so you'll be familiar with the rules, but there's a whole series of rules to follow around giving employees the opportunity to nominate and elect representatives, what that election process looks like, and then some very prescriptive information about what has to be provided to those representatives as well. Now, when the employer is engaging with employee representatives, be it trade unions or directly elected members of the employee population, the law says you've got to engage with them on ways to avoid, reduce, or mitigate the effect of redundancies. And there's effectively a moratorium on dismissals within a 30 or 45-day period of consultation starting. Sometimes that's described by people as a minimum period of collective consultation, 30 or 45 days, but being pedantic about it, it's not quite what the rules say. It just means between launching a collective consultation exercise, you need to wait either 30 or 45 days until the first dismissal under that process actually takes effect. And in fact, consultation under those processes may be longer or shorter than the 30 or 45 days which are required. Whether it's 30 or 45 days, by the way, is just governed by the number of employees that are impacted. The crucial bit of information for what we're talking about here is if it's 20 or more, these rules are all engaged. So just remember that number if you're dealing with 20 or more employees. Now, there are significant penalties if you fail to follow the rules or if you get them wrong. At the moment, it's a protective award of up to 90 days pay, and that means 90 days gross pay per employee. So you can see how that liability can spin up into something quite significant if it's a large-scale change process and you get the rules wrong. Now, when these rules are triggered, is determined by whether or not the change is happening at one establishment. And I've put on the slide here, consider the Woolworths scenario, and I think that just helps illustrate how this can be tricky and the problem or the loophole that the government are trying to close through this bit of legislation. So cast your minds back to 2011, Woolworths, stalwart of the high street, purveyor of pick and mix and all sorts of good goods when you're a child. They had to close, sadly, and they closed a number of stores, and it must have been in the hundreds in terms of the number of stores that were closed down. Now, in closing their operation down, unfortunately, and it may have been a calculated decision, I don't know, but they didn't follow these collective rules on collective redundancy scenarios. They were in breach of the TULCRA provisions on collective consultation. So employees with the support of unions brought claims for protective awards. So that up to 90 days gross pay that I mentioned before. Now, the courts found there had been a breach and they awarded compensation. But employees who worked in Woolworths stores where there were fewer than 20 at that one store did not receive a protective award. And the reason for that was the courts determined that each store was a separate establishment. And bearing in mind what I've said, it's about 20 or more employees at one establishment. So if you were working in a Woolworths that had 20 or 21 employees on it, you were getting the protective award. If you were working at a Woolworths in a different location that only had 19 employees in it, you weren't getting it because they were treated as separate establishments. Now, the government, through this employment rights bill, want to close that loophole. So what are they planning to do? Well, should have maybe left this one up a bit longer. This is the snip from the employment rights bill, this provision, clause 23, and it says in this limb 2 here, in section 188, which talks about these duties for employers to consult with employee reps, in subsection 1, omit at one establishment. So what they're doing is removing the words at one establishment to talk about when these rules are engaged. Now, what does that mean in practice? Well, it means that if you have various sites that you may have previously been able to argue constitute separate establishments for the purposes of whether or not these collective consultation rules are engaged, you actually need to consolidate the numbers across them. Under the current proposals, you'll see on these future slides, I've put a question mark there because we don't know exactly if they're all going to be brought into law in the way that they're currently drafted, but this is what the drafting means at the moment. So you're looking at consulting on multiple sites, but treating them as one establishment. Now, that introduces a lot of uncertainty at the moment over the practical implications of that rule change. So consider this situation. If within a 90-day period you have, let's say, 9 redundancies at a location in London within one organisation, 9 in London, 9 in Bristol, and then 9 in Manchester, 9 plus 9 plus 9, even on my basic maths, takes you over the 20 threshold to run a collective consultation process. Now, previously, or at the moment, under the current rules, you wouldn't be obliged to run a collective redundancy exercise engaging the TULCRA rules across those 3 sites. You would treat them as 3 establishments, and each one has fewer than 20 employees. You can talk to the employees directly. You don't have to involve the unions necessarily. I mean, I'm being broad here. It depends what your recognition agreement says, but let's say there's no requirement to discuss with the unions. You don't have to get the employees to nominate their own representatives. You can just deal with it as what we call a small scale redundancy exercise. That changes massively if you have to consolidate the numbers, right? Because all of a sudden you're dealing with one exercise involving 27 people. And how do you coordinate that in practical terms? It's a bigger administrative burden on you if you have to do that. You've got to build in a longer period of time. Remember the moratorium on dismissals, so it may take a longer time to run the exercise. You've got to bake in time to get reps in place. You might want to give training to those reps on how they can be an effective employee representative. So we've got to factor that time in as well. And it can be a more protracted change management process. And when it comes to those practical points, there's a real issue at the moment around how you deal with uncoordinated redundancies. So at the moment, when you're looking at that 20 threshold, it's 20 employees who are affected within a rolling 90-day period. So it involves an element as an employer of looking forwards and looking backwards around how many people have been dismissed by reason of redundancy within this establishment, and do we need to tot up the numbers to get us to that 20 threshold. Once we hit the 20, right, collective consultations engaged, we've got to comply with what TULCRA says. In my example, so where you've got, different sites in play, London, Bristol, Manchester, what do you do if you've started an exercise in Bristol with 9 people, then a month later you've got an unconnected reason for redundancy in London with 9 people, and then a month later you've got your 9 in Manchester? They're all within a 90-day period. It's the 9 in Manchester that take you over the 20 threshold when you consolidate the numbers. So what do you need to do about the ones that you've already started? Do you have to then go back and undo a process you've started and start collective consultation with those? What happens if you've already given notice of termination by reason of redundancy? Would they be entitled to a protective award because there's been a technical breach of the regulations? So I think all of that needs to be thrashed out. Do you deal with them as separate or single exercises? Like I said, how do you deal with that process if some of those redundancies have already started as well? So one solution is to run a collective consultation exercise as a default. So you're probably not going to do that if it's just one person that's impacted. But if you've got what would be a smaller scale redundancy situation with 9 or 10 people, you might say, actually, we don't know across our entire organization how many more redundancies we're going to have within the next 90 days, within that 90-day rolling period. So we're just going to run collective just in case, or at least mirror the collective provisions. So if we're found to be in breach, we've really mitigated our risk. We can plead at the mercy of the court and say, look, we've done our best to follow the rules here. So that's one option, but it introduces a lot more red tape, I think, and can slow things down for you. The other issue around that, though, is what about notifying the Secretary of State? So again, any of you that have run a collective redundancy exercise where Section 188 of TULCRA is engaged will know you've got to go online, download your copy of the HR1 form, fill that out, send it off to that random email address, which I think used to be the Department of Business. I'm not sure what it's called at the moment. Sometimes you get something back, sometimes you don't. But if you fail to do that, it's classed as a potential criminal offence. So it's really serious, and it's really serious for people at the top of the organisation as well in terms of liability. What do we have to do here with these unconnected separate exercises? So that needs to be resolved as well. There's another change for another day, which I'll float now because the government are talking about it, although it isn't expressly referred to in the Employment Rights Bill. It's in some of the associated paperwork with it, though, and that is consultation on the cap on the protective award. So remember I said the consequence of getting these rules wrong is 90 days gross pay per affected employee. The issue that I think companies have had in the past, and I'm thinking of that particular ferry company as well when I say this, is it's quite easy for an employer to make an assessment of what the liability might look like. They can say, well, if we get it wrong, we know that 90 days pay for this group of employees is going to cost X amount, but we could maybe offer settlement agreements and offer Y amount and effectively buy our way out of trouble. So I think the government are going to examine addressing that by looking at this cap on the protective award and whether it needs to be greater than 90 days or whether there needs to be a cap at all, which does introduce a bunch of other questions which I think are beyond this session today, but watch this space on that. I said there were two elements to change management. Let's just talk briefly about fire and rehire, or dismissal and re-engagement as it's formally called. Now, I'm sure those of you that are joining this call today will not be rushing out to go and fire and rehire people, because it's not a great tactic to use. Sometimes it does need to be utilised, though, as a last resort. But I just want to talk to you about how that is changing. So it's provision 22 within the Employment Rights Bill, and what it does, it inserts specific reference to dismissal of employees in relation to variation of contracts of employment. Now, where dismissal and re-engage is being used by employers tends to be where an employer wishes to change and vary a group of employees' contracts. Maybe they want to remove a particular term on pay or hours of work. They've asked for consent for the employees, and the employees have said, no, we don't agree to this change. And it forces the employer's hand to do something about it. And sometimes employers will say, well, we don't have much option now but to dismiss you under your existing employment contract and then immediately re-engage you under a new contract which has the revised term in that we're looking to change. And typically there'll be less favourable terms, right, which is why there's an issue. What P&O did was they dismissed their workforce and they rehired different employees or different workers. I'm not sure what their category was even. So it wasn't dismissal and re-engagement of the same employees. It was dismissal of one group and hiring others on less favourable terms. And that's relevant for what I'm going to talk about in terms of the change. At the moment, you can do it if you've got a sound business reason for the change. So at the moment you can say, look, we had to do it. It was a response to economic changes. We had to change our work practices. We needed to harmonise T's and C's, and that's why we did it. But obviously there's a really unequal bargaining position there between employer and employee. And, it's really dubious whether there's legitimate consent in those situations. If you're saying to an employee, you've got to agree to it, otherwise we're going to dismiss you. And that's the imbalance that I think the government want to address. So how are they looking to do that? Well, there is going to be a radical shift with this. It will be an automatically unfair dismissal to dismiss an employee if the principal reason is to refuse to agree a variation of contract, or to enable an employer to recruit another person under new terms but with the same duties. Or I think they use substantially the same duties. So firing one group of employees and hiring others as their replacements on lesser terms. This will apply to all contracts. So it doesn't matter if it's an express term, an implied term, a written contract, or an oral contract, law will still apply. It doesn't actually amount to a blanket ban on dismissal and re-engagement. There is a narrow gateway for employers to be able to get through, and they can do that if they can show that there were financial difficulties affecting or likely to affect their viability. The changes were to eliminate, prevent, significantly reduce, or mitigate the effect of those difficulties, and the need to make the change was unavoidable. So that really amounts to a substantive justification defence. So as an employer, can you justify substantially having to make these changes in that way? But really, I think it is such a narrow gateway for employers to try and get through that it kind of almost amounts to a blanket ban on it. And I was discussing this with my colleagues. It would probably be quite a brave employment lawyer who's saying, oh, yeah, you're fine to make these changes on the basis of this narrow provision. I mean, some unfortunate employer is going to get sued at some point, and we'll get some case law on it if the regulations are not giving us the answer. But it seems at the moment on the current drafting, it's a really narrow option for employers to be able to follow there. Again, like with the other provisions, there are some open questions on it. Will it ultimately only be for financial difficulties? Will that be your get out? Will it only be as a last resort? Will the cure be worse than the disease? So will it force some employers into financial difficulties because they can't make these changes and we see increased insolvencies? We don't know. One interesting discussion that's happening at the moment is to what extent can you bake variation clauses into your employment contracts? So could you draft employment contracts now, have any new hires start on something that gives you the contractual right to be able to vary their terms in the future, even if it's a less favourable right? And I think the answer to that will probably be the government will look to legislate for that scenario. They'll look to deal with it within the regulations. So they'll anticipate. Remember what I said at the start, it's about unscrupulous employers. They'll anticipate unscrupulous employers with unscrupulous advisors saying, aha, let's sneak in a variation clause. And I think the regulations will probably address that, but we need to wait and see. I've mentioned on here a consultation on interim relief. Now, those of you who've dealt with any whistleblowing claims ever may know that interim relief is an application an employee can make who's been dismissed and is asserting they've been dismissed for blowing the whistle on something, which is a continuation of employment order from the tribunal. So basically what the tribunal will force the employer to do is maintain that person's employment and pay them until their case is heard. And the government are consulting on whether interim relief should be used in contract change scenarios. You can imagine potentially how much of an issue that would be if you're trying to change the contracts of 50 employees, you're trying to force it through as a dismiss and re-engage, the employees go for interim relief, and pending a final hearing in the tribunal, you've got to carry on paying them in the meantime. I mean, that would be a bit of a disaster, but let's see on that. Flexible working requests. Labour see these changes as strengthening the family-friendly rights framework. I think these changes are material, but they're not particularly groundbreaking. Certainly, it opens the door for more challenge for employees to challenge decisions, and I'll explain why that is. At the moment, employees have a right to request flexible working from day one. I think that was a change that came in April of this year. And the obligation on the employer is to deal with the request in a reasonable manner. Now, the employer must respond within 2 months of the request. And as an employer, you can only refuse the request for one or more of the 8 statutory reasons. Don't ask me to cite off the top of my head all 8 reasons right now, but it's things like an inability to reorganise the work amongst existing staff, if they think the quality of the work is going to be impacted. But you've got 8 clear reasons as to how you can reject a request. Now, the employee can only complain to an employment tribunal as a standalone claim if the employer doesn't rely on one of those 8 reasons, because you're not allowed to rely on anymore, or bases its decision on incorrect facts. Now, the big change here is the introduction of a test of reasonableness. So when responding to a request, the employer must identify one of the 8 statutory grounds, or more than one of the 8, at least one of the 8, let me say. The employer must also explain why they think it is reasonable to refuse the request on those grounds. And the employer may only reject the request if it was reasonable for it to have done so. And that's what's different. At the moment, you don't have this reasonableness test, and the Employment Rights Bill changes that. So what does it mean in practice? Well, it opens the door to lots of employees saying, hey, employer, you rejected my request, and I don't think you were reasonable in rejecting it for the reasons that you've relied on, and I'd like an employment tribunal to make a decision on it. So I think potentially we'll see more litigation in that space, which, presents its own issues because you've got to fund litigation and deal with it somehow. But the penalty remains the same, interestingly. So it's not like they've added any more teeth to the bite. It's still a cap of 8 weeks pay, which I think is 5,600 on current weekly pay caps. So, well, I'll put it there, no real bite, but the pain may be caused by more challenges, i.e. more litigation and litigation time and cost. Harassment by third parties is obviously quite topical because of the changes that are happening, I think, later this week on harassment. What the Employment Rights Bill does is it brings in an extra obligation. So the provisions are in point 16. Excuse me. So from the 26th of October, we've got a slight change to existing rules. Employers are not liable for third-party harassment, although the Equality and Human Rights Commission can take action against employers who they think are not preventing third-party harassment. There isn't a standalone claim by an individual to say, hey, employer, you're liable for me being harassed by a third party. But employers must take reasonable steps to prevent sexual harassment in the workplace. And yeah, the Equality and Human Rights Commission say the preventative duty does extend to harassment by third parties. What does the future look like on this? Well, it's an expansion of the reasonable steps an employer needs to take. Employers will be placed under an obligation to take all reasonable steps to prevent sexual harassment, and that includes harassment by third parties, who are defined as anyone who's not the employer or an employee of the employer. Now, the bill opens the door for the government to publish regulations specifying what steps will be regarded as reasonable, because that's the obvious follow-on question, right? What does reasonable mean in these circumstances? So it means, I can tell you at the moment, it means every reasonable step to prevent sexual harassment, but the regulations are going to spell out more detail, we hope. So that's what we're expecting to see, regulations that really give the detail in terms of the practical steps that you need to take. Right now, employers are not liable for third-party harassment, but you can be in breach of a duty if you don't take steps to prevent it. And so the change here is about being directly liable as an employer for harassment of one of your employees by a third party. So that's the change. Worth noting as well, a disclosure about sexual harassment will automatically be a protected disclosure. So anyone who makes it will be protected under the whistleblowing regime as well. And, you know, that introduces the idea of somebody being protected and then being able to advance a victimization complaint if they perceive that they have been subjected to a detriment for having blown the whistle on something. So there's a whole other rabbit hole of potential liability that comes along with this. Right, they were the main ones I wanted to focus on, just mindful of the time. So in the last couple of minutes that I've got, I just want to talk about some of the other not insignificant provisions that are covered off in this bill. Trade union reform is quite a significant one, in as much as, and again, I recognise that a lot of you probably do have recognition agreements already, but it will be a lot easier for trade unions who are not currently recognised to access workplaces. And the whole recognition process is going to be simplified as well in terms of thresholds needed to show support for recognition. I mean, I've been noticing a trend anyway of increased recognition. I can think of 4 different clients this year we have who for the first time have recognised trade unions, these obviously private sector businesses. So I think that is the general direction of travel anyway. Employers will be required to inform employees of their right to join a trade union, you know, rules like that. Statutory sick pay has been in the news a lot recently since the bill was drafted. We're talking there about day one SSP entitlement and a removal on the lower earnings limit for that. Interestingly, if anybody saw the economic analysis, which was published on Monday, I think, it's been costed out as I think a £3 billion cost. I mean, overall, the cost of these provisions in their current format, and again, maybe subject to change, but the cost of these provisions in their current format are estimated to cost businesses and organisations £5 billion a year, which amounts to about 1.5% of the wage bill. Sorry, no, it doesn't. It amounts to 0.4% of the wage bill. But when you look at the employers that are going to be impacted the most by the changes, it might be up to 1.5% of their wage bill. So not insignificant. And SSP by far makes the lion's share of that. 3 billion a year, I think, was the cost, compared with day one unfair dismissal rights, which is costed out as a cost of about 340 million pounds. So almost 10 times less. Bereavement leave, the government wished to introduce 1 week's leave for bereavement leave. In terms of maternity protection, there'll be a power to introduce new regulations around protecting people who have exercised their right to take maternity leave and then who are subsequently made redundant. So some strengthening of the provisions there. In terms of parental and paternity leave, we're talking about day one rights for those. So nothing especially groundbreaking given the current direction of travel as well. If you want any further resources on this, I will just shamelessly plug our videos that we've got on our site. So we've got some education pieces on there. We did a deep dive into probation periods specifically, so you can find those on our website. We also have a podcast where we discuss these changes as well, and I am also pretty active on LinkedIn, and I've got lots and lots of stuff to post about at the moment because the government are keeping me so busy. So please do follow me on LinkedIn and you'll get those updates as well. The government are producing fact sheets at the moment, so there's a lot of fact sheets, and I would say do contribute to the consultation process as well if you want your voice heard, because obviously you've got an opportunity to feedback directly to the government and have your concerns raised, so do avail yourself of that opportunity as well, at which point I'll hand back to you, Ben.
So you can take a breath and a sip of water now. That was a lot of ground covered in 45 minutes or so, but thank you very much. Hopefully everyone's found that first half of our session today useful, and the NPM podcast is of course not to be confused with the Southeast Employers HR Edit podcast. So we'll compete with you on that one. Right, folks, I'm going to keep this transition really short because we have got still a good amount of ground to cover today. I'm now going to send everyone off into some breakout groups, and what we're going to ask are three questions. And I suppose what we just heard from Peter there, it was kind of our take in liaison with Peter on some of the key things that might be most applicable to councils in our region. But what we're really keen to understand now is actually what you think are the things that might be most applicable or have the biggest impact for your organisations. So we've got three questions. I haven't got any PowerPoint slides, so what I'm going to do is I'm going to read them out. I'll put them in the chat of this meeting, and once the breakout rooms open, I will also try and get them into the chat of the breakout rooms, so you've got them to refer to. The breakout rooms won't be recorded, by the way, so they're a safe space if you need to discuss anything that you perhaps wouldn't in an open forum. Question one is what does the Employment Rights Bill mean to you and for your organisation, i.e. what areas will have the most impact on your employment practice or on your workforce based on the type of services you deliver? What challenges might it present? And therefore what policies, procedures or practices might need updating? And bear in mind that starting to think about updating some of those might need to happen in the next 12 to 18 months because of the process that policy updates and so on have to go through. And finally, what ideas have you got to overcome those challenges and make any updates or improvements? And it's really that final point that when we reconvene after about 15 minutes of the breakout groups that we can put to Peter for an expert view based on what we currently know. So I will press all the magic buttons for the breakout groups now. They're all randomly assigned, so apologies if you end up with somebody that you know or is from the same organisation. It's just random. We've got 6 breakout groups, so I'll open those now. You'll be automatically moved over and you'll be automatically timed out after 15 minutes when you return back into the main meeting. So keep an eye on the time, network, introduce yourselves, have a chat through these questions. And if we might not be able to get around all of the groups to get some notes down. So if someone could just be prepared from each group just to give us a really high level feedback on perhaps what the 2 or 3 key things coming out of your group were, that would be much appreciated. We'll be asking for that when we reconvene. So I'll open the groups now, and good luck. I think everyone's just dripping back in from the groups. Thanks everyone for your input in those. Hopefully everyone, or just about everybody, is filtered back in. there was certainly a couple of groups I joined. There was some good discussion. So I think, Peter, we've got some bits to throw at you, either as statements or questions. But so I'll kick off. I think from the two groups that I dipped into, the main concern was around probation in both, and the changes there, which don't need repeating. I think the concern is there needs to be something in time, not now, to an exercise to look at what good looks like or what reasonable looks like in that new world, and actually that could be a challenge. The actual day one rights for unfair dismissal as proposed, not such an issue. I think there's a feeling that actually organisations with us today have already got what they feel are fair and reasonable processes, and actually there isn't that kind of, we'll do something that we wouldn't normally do just because somebody doesn't have that right. So there's perhaps not as much nervousness on that. There are concerns about consistency, and you mentioned that, Peter, particularly around application of probation, as it is line management led from day one, and around induction, and actually how do you bring somebody into the organisation to help them land in the role. And the other sort of key things that came out were just around the consultation piece for change management, on the establishment angle of it, and flexible working. So sort of some correlation and alignment there to the some of the key areas that we'd identified, which is good. There was a concern around barriers to policy development in local authorities. There's often a very long-winded route, particularly with some of these key employment policies, like probation as probably the number one example, that there's a lot of hoops to jump through to get a new policy in place, and potentially there's a situation where the organisation is mandated to have a policy that covers X, Y, and Z and meets forthcoming legislation, but is meeting opposition from stakeholders internally around what that should look like, and potentially that getting quite messy. So that was the feedback from a couple of groups that I dipped into. I don't think there's any questions there. So I don't know, Chelsea, Claire, if you've got anything from yours.
Yeah. Well, Group 5 were very well established, and Vicky's going to kindly feedback from what they were talking about. But in terms of Group 2, the 3 areas of concern, one we didn't speak about, which were the 0 hours and the 0 hours provisions and the potential impact on casuals. Because whilst councils don't typically use the kind of 0 hours contracts you find in possibly hospitality or retail, a lot of councils have quite a high number of casual staff, or casual workers. So the impact potentially on those. Dismissal and re-engagement we talked about in terms of some councils having long-serving employees with perhaps contractual provision for things like allowances, which you may want to remove because they're now over generous or out of step or whatever, and how to do that. If the employee won't agree to it, does that mean you simply cannot do that now with the fire and rehire rules? So a question coming up really in terms of what then happens if you face an equal pay claim from somebody else in the same role who's not receiving the same level of allowance. Would that be a defence to say, well, actually, we can't vary this contract because we're legally prevented from varying this contract? So that's an interesting question. And also some concern about the one establishment, and the fact that local authorities are quite varied beasts, and, a few redundancies in a school over here, and one service at HQ and another school somewhere else, or, a children's home or something. And suddenly you can be making 20 people redundant within 90 days, but without any knowledge of that at any point. And whether there's maybe an opportunity to feed into the consultation to try and change that so that the nature of the establishment is taken into account. So, for example, in the Woolworths scenario, they're all shops, so they're all the same type of establishment, but whether there's an opportunity to address that by saying if the purpose of the work and the function of what was formerly one establishment could be taken into account in that. So I don't know, Vicky, if you want to come on in and give feedback from group 5.
No, we would just it's probably touch upon what's already been said. We focused a lot on sort of the flexible working and the practical impact that might have on the organisation. The sort of the burden really falling on managers to justify the reasonableness, and how if we refuse a request, these sort of what we could put that on, and whether it would result in perhaps more trial periods for when an employee has requested a flexible working request to see if it does actually work in practice. But then, of course, the manager needs to be able to really monitor that. We talked about probationary periods and sort of the impact on the perhaps managers really having that performance management culture, particularly in the early stages. And we focused on sort of fire and rehire and the impact on rota changes, because in some parts of the council there can be consultations on rota changes, and would it make it automatically unfair to change someone's rota pattern if the business need requires it. So they were the sort of things that we discussed, and we sort of felt it would be more policies, it'd be more educating managers and more training, that would be the impact on the organisation. So that's all I had. I don't know if anyone else wants to chip in from the group.
I think you covered it well, Vicky.
I'm of course happy to talk to some of those points that have been flagged.
Okay, go for it, Peter, and thanks, Vicky and Joe also.
And anybody else with opposing thoughts or complementary thoughts, do chip in as well. I don't mind at all. So in no particular order. So the rota pattern in terms of the fire and rehire provisions, I would imagine you're going to be okay on, because if you've got a well-drafted employment contract, it'll anticipate within the working hours that there's scope for rota working. So when I think about businesses that I support that are in manufacturing, for example, and they have shift patterns, or if they're in the hospitality sector and it's rotated working, again, you know, different types of shift patterns, it's already baked into the employment contract. So, I mean, that is probably a good example of a preparatory step to take. It's making sure that your contracts of employment in those scenarios are currently fit for purpose. And maybe one watch out there is it's not uncommon to have a disconnect between an employment contract that maybe is quite old now and out of date, and the actual pattern somebody is working, or the day-to-day arrangements that you have them on. So are those two things back in sync? Can you get them back in sync? But if you've got the contractual ability to require your employees to work a varying rota, and you need to change it within the confines of what the contract predicts and provides for, I don't think that you're going to fall foul in terms of the dismissal and re-engagement narrowing. And, you know, bearing in mind what I said, I think it almost amounts to a blanket prohibition on it. I've got another question to answer on that, 1 second. And that is, excuse me, in relation to, I think somebody asked or made the point around allowances, and so changing contracts to maybe remove a rate of pay allowance, and how that might feed into equal pay as well. Have I remembered that correctly? I think maybe it's from your group then.
Yeah, it's allowances and things like mileage rates and things like that.
Yeah, I think I think if they exist as a contractual entitlement, so they don't fall into the realms of something that's discretionary, where you've got the leeway to be able to flex on them. So it's a pure contractual entitlement, and you're looking to change that contractual entitlement. If the employee consent on that is not forthcoming, then it is going to be nigh on impossible, I think, to be able to force that change through in a way that you might currently be able to under the law, because of that really narrow gateway I talked about, which is, it's unlikely it's going to be something which is going to cause impending financial doom for that one change. So, that's the narrow gate you've got to try and get through as an employer. It's showing that you're facing imminent financial difficulty, and that helps to justify, or that is the sole justification for the change. And that's why it's so narrow. It's just talking about financial difficulties. How that links in with equal pay claims, if you're talking about harmonisation of contractual terms, is an interesting question, because you're looking at, without going down the warren of, we know how technical equal pay claims are, but you're looking at your genuine material factor defence, and what are the genuine material factors that you're relying on. Maybe the answer there is you've got to bring everybody else up to that level, rather than removing pay awards or other entitlements for other employees. So nobody's going to complain about having their pay boosted up. The people where you're at risk is pay elements being removed or allowances being removed. So if you're then raising other people's pay or allowances, you're going to be doing that by consent, because presumably in those situations, employees are going to say, yes, please, I agree to this change. So you're not then into the realms of unilaterally making a decision. So I think that's my thoughts about fire and rehire. Just bear in mind, at the moment, the way it's currently drafted, it is just this super narrow provision that the government is saying is going to permit it. Otherwise, it's not going to be useful anymore. I'm not surprised that probationary periods have come up, and I think of all the changes, that's the most significant, because it's going to impact every single business, whereas not every single business has trade union recognition, and not every single business is going to be in fire and rehire type scenarios, or have the weight of employees to run collective changes. So I think probationary periods is the big one. The good news is these changes are not coming in until autumn 2026. So you've got a long time to get your processes in order. And it doesn't surprise me if you're saying, well, actually, generally we take a fair approach to our employees. It doesn't matter if people are short service or not. We like to do things fairly, and we like to follow proper processes. I think you've got an opportunity between now and then to really refine what you want your own process to be. Road test it. I mean, you've already probably been road testing certain processes, but use this opportunity to make sure that everybody is singing from the same hymn sheet. So you've got consistency of approach, and people are following the same process and doing, what perhaps a published policy says, and getting into the habit. It's kind of like embedding those good habits now. So when the change comes in and there is a statutory probationary period, you're not really having to change very much. You've already got it baked in. I think somebody made the comment about what does good look like. We're going to need some guidance on that, and I fully expect the regulations will expand more on this concept of a light touch process. Now, those of you who've been sort of in this world and operating with HR and employment law for as long as I have, will remember, maybe with a shudder of horror, the statutory dispute resolution procedures, where they set out very prescriptive rules around people being accompanied to meetings, and if there was a technical breach, there was legal liability. And they weren't very successful at all, because they just created a whole load of satellite litigation around whether rules had been followed in relation to dismissal processes and procedures. Hopefully, I'd like to think we're not going to be back into the realms where we've got to follow a really regimented process like that. But I think it'll be really, really helpful to organisations to have a framework, at least, even if it's just before you decide to dismiss during a probation period, there needs to be at least one probationary review meeting. You have to provide written reasons for dismissal. And I think one point that I spotted I've not included it on the slides, but I'm sure the government are looking at giving people a legal right to be accompanied to a probationary review meeting, so by a colleague or a trade union representative, so to have a companion to those meetings. That's all that the framework might actually look like, and then it's up to you to craft and create your own internal processes on what you want good to look like. But there's no reason why you can't start doing the preparatory work now to get those things in place, road test them, embed them, and have everybody working to them, because you have got this long lead-in period, and then we'll just see in the meantime what the regulations say. Any other questions on probationary periods while we're talking about that? No, okay. I think, what else did I jot down? Oh, so there's a good question or good point around flexible working and reasonableness, and whether there might be more trial periods. So the main point about flexible working is the introduction of this reasonableness test, i.e., as an organisation, we were reasonable in rejecting your application for one of these 8 grounds. Now, I actually think if you're an enlightened organisation already and you're doing a good job of dealing with flexible working requests, you'll probably be doing everything you'll be expected to do anyway. Because I think when I see a well-drafted response letter that is rejecting a request, it will go into a decent amount of detail as to why the request cannot be accommodated. So instead of just saying, dear employee, you've asked for this change to your working pattern, we can't accommodate it under, this ground of the 8 statutory grounds, full stop. Normally there will be an articulation, an explanation of why that is so. And it might go into, we don't have a big enough team to reallocate the work. We need to provide client or customer coverage among core hours, which are these hours, and your proposal doesn't cover that. Whatever it is, normally I will see an explanation. And I think that goes to this reasonableness point. So I would imagine that a lot of you are well on the way to satisfying what you'll need to satisfy anyway. But if you're not, again, use this time to get people into the habit of understanding the legal framework of flexible working requests in the first place and how there can be risk around indirect sex discrimination claims. Having people understand the rules and policies that you have in place. So a good education piece, just as a refresher. So people who are dealing with those requests know the framework that they're working within. And kind of modeling best practice, so showing them what good looks like as an example of, if you can't accommodate the request, this is how we explain it. If we can't accommodate the request but we can accommodate an alternative, here's how we explain that. And making use of trial periods. I mean, the good thing about trial periods is you can be super clear that it is a trial. You can review it at the end. If it works, it's demonstrated that it has worked and you can put it into place permanently. And if it doesn't work, it goes to the reasonableness of showing, hey, look, we were open to trying this. We did the trial period and we can show for these reasons it's not reasonable for us to put it in place on a permanent basis. So I think make use of those tools that are at your disposal. I do expect more litigation on that front, just because I think more aggrieved employees who haven't had their requests accepted will look to challenge it, even though the compensation regime at the moment is not proposed to change at all. And then I think there was a point about establishments as well, which is obviously a concern. I mean, it's difficult in terms of establishing the test for establishments and what you look at, and whether you look at things on a geographical basis. And the general rule of thumb that I take is looking at whether an entity has its own management structure and has its own financial responsibility. So within a school, for example, I think there's probably quite a good argument that they are standalone units with their own management levels in there and with their own accountant practices and financial remit, compared with an organisation that has, say, a centralised management function but 3 different sites. I totally recognise that some schools are more than one school, of course, and they may be caught. So where you have like a trust type, an academy trust type setup, where there's more than one geographical site, each school might have its own management structure, but reporting up into a higher management structure and ultimate financial reporting at the top. I think you probably have to think quite closely there about what you class as an establishment. But yeah, it is going to be a challenge, because I think the government are going to be wanting to encourage more collective consultation in these types of changes, and that feeds into all of the changes around trade union changes as well. I mean, if I finish on this note, the explanatory notes, which are worth a read, by the way, I think there's about 10 of them that have been published, but the explanatory notes or guides to the different changes, the one on unfair dismissal is barely 2 pages long. It's like just over 1.5 pages. The guide on trade union changes is 13 pages long. So it just gives, gives an idea on where some of the changes, where the focus is.
Peter, really useful. There's a couple of points in the chat which I'll just come to briefly before we close. I think one is from Sally, just around obviously the funding constraints that a lot of councils, all councils, are under. Going back to, I think that was on the equal pay point, Sally, but please correct me if I'm wrong in terms of that. Actually, the practicality of bringing other pay up, it simply isn't there. So there's potentially the challenge in those scenarios where we're trying to remove certain allowances or payments being made. The question, I'm going to combine Zoe and Lynette's points here. I think there's a question just about basically, what about just altering someone's working hours generally? So there needs to be a reduction in hours, an increase in hours, and there's nothing, and there isn't necessarily provision in the existing contract to do that. What happens there?
Yeah, that's the challenge. It doesn't look like dismissal and re-engagement is an option. And then question mark, are you into the realms of redundancy situation? Because you're saying, well, our need is not what we have at the moment, it's something different. So it's going to take a lot of thought, because the best scenario there is that you incentivize the employees to agree to the change and it becomes a variation by consent. So you give them enough of a reason why. But what you can't do anymore is wield the metaphorical stick of, well, we may have to dismiss you if we can't agree this change, which is what you can do at the moment. I mean, I don't comment on the whether that's a good thing to be able to do at the moment, but that is certainly an option that's open. And that's what you're going to be deprived of. So you need to start thinking more creatively in terms of what's going to encourage these people to agree to that type of change.
Thanks, Peter. And I think that will be an interesting one, because certainly in perhaps more localized situations where you are dealing with one or two people in terms of changes of hours, I think that will be a challenge rather than something that is more structural, where perhaps collective consultation might be engaged and so on. That's everything we had in the chat at the moment, colleagues. We have got a minute left, so if anybody wants to chuck anything in there, or you can unmute, you can do cameras on and all of that. We have a brief moment if anyone's got a closing question or thoughts that they wanted to add. I'll open up the floor. Failing that, can't see anyone jumping up and down. So failing that, colleagues, I'll bring us to a close bang on time, which is good. Thanks very much for attending. Thank you, Peter, for joining us. Thank you,
Welcome,
Claire and Chelsea, for jumping into breakout groups. The recording will be sent round to everybody, and we'll follow up in the usual way with a bit of post-event info. So look out for that. But thanks very much, everybody. Enjoy your evening and your day, what's left of it, and we'll hopefully see you again soon.